Hi, this is Dave Waller. Thank you for joining us for the San Diego Inventors Forum General Meeting. I'm the president of the San Diego Inventors Forum, and I'm giving the presentation this evening on some common misperceptions that on patents and the patent process. We're going to kind of go through that just a little bit. The patenting process is somewhat complicated, and so it's not surprising that there are some misconceptions, but if we understand what those misconceptions are and reorient ourselves, the process becomes a little bit easier. So let me start. Next slide. This is this is a slide pretty much on my experience, so you better know who I am. I'm not really going to go through it. Suffice it to say, I've been a patent agent for about 25 years now and have worked on anything from simple mechanical devices all the way up to extremely complicated drug development processes. So at this point, let's get to our first question, or actually our first statement. So next slide. So where does an individual such as yourself or myself get the power to have a patent? Well, there is legislative power with respect to obtaining a patent, and it's actually written into our Constitution. If you look at Article 1, Clause 8, it actually provides that those particular individuals who are inventors can obtain property rights to those inventions. Very different from what we used to have with the Crown before we separated and became the United States. Next slide. So what's the first question that I have for you guys that there seems to be some misconception on? A lot of people come to me and they say, I've got a great idea, I need a patent. My wife has done that. And so the question then becomes, or my first question is an idea an invention? Think about it. Is an idea an invention? Is it true or false? Raise your hands. No, I can't see you anyway, so it doesn't matter. All right, so let's answer that question, and I'll give you some explanations why. It's actually false. The patenting process is a process that gives somebody a property right provided that that person adequately describes how the invention is to be made and how it operates in that patent document. That's the exchange. The exchange is, you tell us what it is you do, we'll give you exclusive rights to exploit that technology, but in the end, after that time period, you're going to give it to the people. And that's part of the exchange. So in this case, isn't an idea an invention? Well, it depends, I guess. In reality, idea doesn't mean that you have fully conceived what that invention is. You haven't, figured out a way how you would construct it, put it together. So for example, I always use this as an example. I have a device like this as an idea. You speak German into it, I bring it back and it speaks English back to me. Is that an invention? Well, no. That's an idea for an invention. The true invention is the software in this device that is able to convert German to English so I understand it appropriately. That's actually an invention, and that would be patentable. The idea of having a device like this do this particular function is merely an idea. So what is the next misconception? What's the next question? A lot of people think that they need to have a prototype before they file a patent application. Make sure it works, make sure everything's okay, we can get it off the ground. I've shown you an image here of a flying machine. Obviously, if there was some mistakes in the physics there, we would probably have a problem getting it off the ground. But the question here is, do you need a working prototype to file a patent application? True or false? Well, it's actually false. Now, it doesn't mean you shouldn't develop a prototype. Figure out if it works. Make sure all of your conceptions are correct before you move forward. All it means is that the United States Patent and Trademark Office does not require you to produce a prototype and say, if you don't have a prototype, you don't have an invention. That's not true. They say as long as you adequately describe such that one skilled in the art can make and use what you have described, then that's adequate enough. So the question in legal terms would be, is actual reduction to practice required to file? No. It does not have to be an actual reduction to practice. You can perceive a reduction to practice, but to some degree, with that perception, One skilled in the art, taking what that perception is, doing what normal people or those skilled in the art would do, or able to get that invention, it's good to go. If they can't, then it becomes a problem. Next slide. Next question. Disclosure. And I've heard this before. I'll put it on my website and see how it sells, and then I'll apply for a patent. Because then I'll know if I'm not wasting my money when I apply for a patent. Good idea or bad idea? Well, let's find out. Next slide. Not usually a good idea. There's a plethora of reasons why. The United States Patent and Trademark Office wants to give you a property right to your invention, but they don't want you to disclose it to the public and then ask for that protection. They're going to give you protection as the first inventor to file. If you were to put it on your website, not filing a patent application, person were to see it, prepare a patent application and file it, you could lose the property right to that invention. So this is really not a good idea. It might be a good idea to do a beta test with some specific people that you have contractual agreement with not to disclose, and get their ideas on whether or not the invention is a good one, whether they would buy it, how much they would spend for it, and so on. But disclosing it before filing a patent application could amount to you losing your rights. It certainly amounts to losing your rights if you intend to file overseas, because as soon as you disclose it, overseas patent rules and regulations usually will prevent you then from filing a patent because it has already been disclosed. So is this a good approach under the current patent laws? No. Again, the best approach here is if you have an invention and you believe that you are able to disclose it in such a way that one skilled in the art reading your disclosure can make and use the invention, it's better for you to file a patent application first and then figure out what it is you're going to do. The actual cost to do that is, well, again, the filing itself, the fees are around $900 at this point in time in 2021. Preparing the patent application with a skilled individual may be anywhere from $3,000 up to $7,000 or $8,000. But is that a good investment? It could be a very good investment, because if somebody can come in and take that invention away from you because you put it up on the website, then you've got a problem. All right, next slide. Trade secret. So there are some individuals who have inventions that they believe would be better kept as a trade secret. So they don't need a patent. They're not going to file for a patent. That costs money. They're going to implement trade secret, which doesn't necessarily cost any money because you're not really filing anything, and that's the way they're going to do it. Good idea or bad idea? Okay, well, next slide. Let's see. Well, could be a good idea, and it could be a very bad idea. The one thing we need to know about trade secret is that trade secret is provided to individuals who would like to implement trade secret if they follow particular rules that allow the courts to enforce trade secret. If you do not know what those rules are and you do not follow those rules, a court will not support your trade secret contention. Okay? So in this case, is it a good idea? Well, it can be. Look at Coca-Cola. Coca-Cola, the formula for making Coca-Cola, is still trade secret 100 or so years later. That's a good thing. They have the resources, they have the money, they have the attorneys, and they have the law firms behind them to keep it trade secret. Most people don't have that type of resource. But there's a downside to trade secret as well. The downside to trade secret is if the formula of Coca-Cola gets out, that's it. It's over. It's already out there. You can't bring it back. And if you're only using trade secret, the courts can't help you. So there's a trade-off. If you think you can enforce a trade secret within your corporation, within your company, and you can keep it that way for several years, let's say beyond 20, which is what a patent term would be, maybe that's good to go. It's a hard thing to do, just so you know. So oftentimes, patenting is the best option. Yes, after 20 years, you have to give it to the public, but hopefully within that 20 years, you've exploited the technology, you've already gone through your growth curve, and you've made your money. Now you can move on to the next invention. So what's the next question, rights. This one is a tough one because people see patent rights this way. A patent allows me to make and sell my invention. Right or wrong? Next slide. Not true. A patent allows you to exclude others from making and using your invention. It's an opposite right of a positive right. It's really a negative right. So are patent rights an absolute right to make and use? No, not necessarily. You may have a patent on an invention, but you may be excluded from actually making your device because your conception may also be protected by somebody else's product, and you may need a license for that to be able to produce yours. So that's certainly one of the things we take a look at when we do a patent search. We're trying to find out whether or not there are other prior art that are going to be a problem with respect to you either making and using your invention or preventing you from getting a patent. Next slide. Cost. This is a tough one because everybody who comes to me and says, I want to have you prepare a patent application, how much does it cost? Well, it varies because preparing a patent is not prosecuting a patent. Prosecuting a patent is not getting a patent and enforcing a patent. So I can tell you that in general, you will probably run between $25,000 and $30,000 to get a patent that's enforceable on a simple device. So is the patent the most expensive part of bringing your invention to the market? Not at all. Next slide. Not at all. In general, I've wrote here, neither true nor false, it really depends. It's true, it depends. But in reality, if you have a product that requires molds to make, which have to be assembled, which then have to be packaged, which then have to be shipped somewhere, to then be stored, your patenting costs are probably 1/10 of the actual cost of what that's going to entail. Correspondingly, the reason I say maybe neither true nor false is, so maybe I'm not the one bringing the invention to the market. Maybe I'm just patenting it, licensing it, or signing it. Licensing meaning I'm giving somebody else the right to make and sell the product, but I still retain that property. Assignment means I sell that property right and I have nothing to do with it after that. So in that circumstance, the patent cost may be the most expensive because after that I'm really not doing anything, the licensee or the assignee is. So what's the next question? Application. Some people have come to me and said, look, I want you to file a patent for me, but I want it to be a provisional because provisionals are cheaper, right? So the question to you is, do you believe that provisional patents are cheaper? I'll tell you why you might say yes, because initially when provisional patents were given an opportunity to be an application in the application process, it was touted to be inexpensive. But what really? Next slide. False. Why is it false? As I told you early on, a patent right is granted by the United States government provided you teach how to make and use the invention in your application. It doesn't change because you're filing a provisional or you're filing a regular. You have to teach how to make and use. If you haven't done that in the provisional because you want to save money, or you haven't really thought it out, so you're just going to say a little bit here, you've got a problem. I have had clients who've come to me with provisional applications which don't disclose what the invention is. It basically tells you why the invention is terrific and wonderful, but really not how to make and use. So the provisional filing, for whatever cost it was at that time, I think it was $160, was really wasted, and no priority date was secured at the time of the provisional filing. So you have to be careful. The same rules apply whether you're filing a provisional or regular application. You must teach how to make and use, and I recommend making sure that you go through the whole plethora of possible ideas that you can think of to either substitute for parts that you already have in there or ideas of how to use that aren't basically considered initially but could be used later, and put that all into the application. Whether you file that application provisionally or not, that's up to you. But the cost for preparing should not be different. It should be the same. And in my realm, that's around $6,000 or $7,000, because if it's a provisional, it's not going to be $1,500. So next slide. Drafting. I can draft and submit my own patent application. Is that true? Well, next slide. Absolutely. The government provides that you do not have to use a patent attorney, nor do you have to use a patent agent to prepare or file your application. However, the patenting process, as I said earlier, is somewhat complicated. There are a lot of rules that the government likes for the applicants to abide by to assure that everything goes well during prosecution, meaning prosecution of getting an application to a patent. And to follow those rules are necessary, otherwise you're just going to run into difficulty with respect to prosecution. So if at all possible, it's recommended to either use a patent attorney or a patent agent to prepare your patent application. I would not recommend doing it yourself, although you can. And I have had at least one client who had prepared a number of patent applications for his corporation and knew what he was doing, and while he was not a patent attorney or agent, he did a great job. Next. Rejection. If the office rejects my claims, I won't get a patent. Is that true? No, it is not true. What the patent office is trying to do is they're trying to find all prior art that's out there, throw it at you and say, here, tell us how your invention is different from this prior art. They're not doing it to be mean to you. What they're trying to do is they're trying to set up a prosecution history. Why is that important? That prosecution is history if your patent is ever challenged. I've been in litigation before, and my job, since I was not an attorney, my job was to invalidate the prosecution's patent application based on the prosecution history. Anything that I can find in there will bring a question to the jury. And if there's a question in the jury's mind, there's a possibility that that claim or that patent may not be considered valid. So we have to be careful. A rejection of all your claims is not a bad thing. A rejection of your claims is a very good thing. Next slide. Prior art. What they don't know can't hurt me. I know there's stuff out there, but I'm not going to tell anybody. So if I don't tell anybody, we're good, right? Next slide. No, that's false. Again, if your patent is ever challenged, they're going to hire me again. I'm going to go out there and I'm going to look at the prior art. If there is any prior art that's out there which is relevant to your patent that was not considered during prosecution, your patent is in question right off the bat. And I will make a strong argument to say to the court and to the judge why I think that particular reference or references were relevant and were not considered, and that would be a problem. So why should you disclose everything to the examiner during prosecution? For exactly that. You want him or her to see everything so that they can get their arguments straight in the prosecution history. So when you prepare your arguments against those rejections, they become a matter of record and can be used in a court of law if your patent is challenged. We're at the end here. If you have any questions, please feel free to ask. I should be available to answer those questions. Sydney can forward them to me and I can repeat them and answer them. If you have any other questions after this presentation or at some other time, please feel free to give me a call. My phone number is on this slide, and also I have contact information where you can get in touch with me via email. And again, thank you for coming and thank you for attending the San Diego Inventors Forum.